Welcome to the Roetzel HealthLaw HotSpot. HealthLaw HotSpot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the HealthLaw HotSpot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Roetzel and James. And today I'm joined by my colleague, Jim Drake, also from Roetzel and James. Welcome, Jim.
Hi, welcome. Hello.
Today, we're going to be talking about lease issues. Jim frequently helps me when my doctors have real estate and lease related issues, whether it's on a day-to-day basis or whether they're trying to do a transaction. So I thought it would be a great idea to talk about some of the frequent questions that we get to help those of you out there that may have these questions yourself. So why don't we start off by just kind of talking about what is one of the most common questions that you think our clients call to ask us about their leases?
One of the big ones is doctors who have an empty space and want to sublease, want to allow another doctor to come in and use the space. And most leases require the landlord's consent to do that. So
they need to keep that in mind. So a lot of times I might have doctors and a good referral source wants to maybe just come in once a week and use the office. So they might set it up on their own. So they might be in violation of their lease if they didn't check it first. But also for those of you listening out there, if you're doing healthcare and you're a doctor or dentist, and you see any kind of federal patient, you also need to make sure that sublease arrangement complies with federal law. So it's not just something you can kind of set up, on the fly, kind of loose. And one other thing I might notice, I recently looked at a lease where it said if you wanted to sublease, even if it's just an office space, you actually need to provide a full set of financials to the landlord. How often do you see things like that?
Well, it depends. I mean, if I know in advance, we will negotiate in the lease that the space sharing is allowed. So if we know that doctors want to do that, or if we know that it's common practice for that particular physician, we will negotiate in new leases that they're allowed to share space, have office sharing arrangements. As long as the sublease doesn't provide the big concern of landlords is, one, making sure that they're paid, and two, making sure that you're not profiting off their space. So one of the issues is, if it's merely like a space sharing arrangement and not a profit generating source, usually the landlord will say, okay. So, you have the extra space, you need somebody to use it, it's 1 day a week, you want to have the office open every day, so on Wednesday you let somebody else do it. Usually the landlord's okay with that. So.
Okay, that makes sense. That's a pretty frequent arrangement for a lot of our doctors, so I kind of want them to realize that sometimes they come to us and they've already been doing that arrangement for a while and they have just some horribly written piece of paper that the landlord would never have approved of, and it doesn't comply with the law. So to me, that's a really big deal. Another question that I pass on to you quite often is clients who are having issues with things like air conditioning. And I was relating to a story I'd heard about some OB-GYNs where their air conditioning was down. They were unable to see patients and they lost a lot of their inventory, drugs or injections or whatever it is they had in their office. I guess for every different specialty, there might be different things in your office that you might lose. What can a dentist or a doctor or another tenant do? And when are they out of luck under those kind of circumstances?
Well, I mean, first of all, it depends. In some leases, the tenant is actually responsible for maintaining or repairing the air conditioner. So in those leases, the doctor himself is going to have to call the repair service and say, come on in here, the air conditioner is broken, you need to come in and fix it. In a circumstance where the landlord is responsible for it, the landlord is usually given a reasonable amount of time to get it repaired. Now, a week is not reasonable unless for some reason, like a heat wave, they can't get somebody yet because they're not quite the emergency situation yet. But usually the landlord, if the landlord's responsible, you got to make sure the landlord knows right away that the air conditioner is broken and needs to get somebody to fix it. If you're responsible for it, you just got to get somebody in there as quickly as you can. So,
what kind of things do you think tenants are typically responsible for otherwise? What about a leak from a unit above, or what about a heating issue, is it the same kind of thing? Like you have to look at your lease to see who's responsible, or are there certain things where landlord is always going to be responsible?
No, the air conditioner is one that where the tenant is often responsible. The leak above, usually that's the landlord's issue, because when it involves things happening outside of your unit, the landlord is usually responsible. The air conditioning is oftentimes wholly within your unit, and therefore the tenant's responsible. Ice buildup outside, that's usually the landlord's buildup. You know, the making sure that the entryway is clear to come in, making sure the driveway is clean, the parking lot's cleared. Usually that's landlord, but if you have the entire building, that could be you. So that could be the tenant. So
I think it's important. I think a lot of times people don't understand what they've actually agreed to in their lease, which can be a real problem. So you and I sometimes very often deal with transactions or practices where somebody might be buying a practice and taking over a lease, or a lease has come up for renewal, and that can present an opportunity to renegotiate a lease. And so at that point, sometimes you're telling people, well, your lease says this and that, and they had really, no idea. And then the new person coming in does not want to agree to some of those terms. So how successful do you think one can be in renegotiating a lease that we're hoping to take over or have renew at that point? And I don't know if this is too loaded a question, but what kinds of things do you think really need to be focused upon at that time?
Okay, well, one, if you have been a good tenant and the landlord is comfortable with you, you often have the ability to renegotiate a lot when you come in. Now, when you're a new tenant, landlord doesn't trust you, they're worried, they're nervous. You prove yourself. It's a lot easier to keep a good tenant than it is to go find a new good tenant. So at that point, you often have a lot of opportunity to renew, to renegotiate certain terms of the lease. If you are a buyer, you're going to have to prove, you're going to have to give them financial information and make sure that the landlord accepts you as the new tenant. At that point, sometimes they are willing to renegotiate. Sometimes, like if there's a year lease, a landlord will want to extend the term, so you're able to negotiate based upon, giving a new deal, getting a longer deal. Those issues there. The underlying terms of the lease, we're usually not as successful in negotiating. So, go back to the landlord issue, to the air conditioning issue. If the original lease says the tenant's responsible for the air conditioning repair, usually that's not something that we're going to be able to renegotiate when we take over for a new tenant. Oh, we can try, but that's not usually one that will change. What will change will be a term, the rent amount. If you're going to extend the lease, you might be able to get some improvement allowance added. So those are the issues that usually we are able to negotiate.
Do you think that most landlords are receptive to a broker coming in and trying to negotiate that? I know, we've spoken to brokers on this podcast before, and I'm always curious because I know recently you've been working, with some of my clients and their brokers. And do you get a sense that they don't mind that, or that they would rather just hear from the lawyer or the tenant? Do you have any sense of how they feel about brokers?
Well, I mean, if the one concern that landlords have about brokers is the obligation to pay them. So I mean, if I call, if I'm dealing directly with the lawyer for the landlord feels no concern about having to pay my fees. That's not going to happen. The broker, they're obviously concerned that, will they have to pay a commission to the broker on the renegotiation of the lease that's already in place. And so that is something that they are concerned with.
Right. But I find brokers actually can be really effective on some of these real estate deals, especially if the landlord is willing to pay. I think that's been our experience, is they bring a lot of, knowledge and relationships sometimes to the table, and a lot of good ideas, because they actually are seeing a really high volume of these type of negotiations going on.
For new leases, absolutely. For new leases, the brokers actually be very, very helpful. in negotiating. It's the renewals where the landlords probably don't want to deal with the broker because they are, why would they pay a commission on a lease that's already in place?
Yeah, I get it. I guess every case is, if you get a bad feeling or bad feedback when you have a broker call on your behalf, I guess you can always then have your lawyer kind of step in and handle it instead. That's a great idea.
But on new leases, brokers can be very, very helpful, very effective.
Right. And that's been my experience as well. And, we work with a few that do a really great job. I'm always just kind of curious, were they needed? Did they bring anything to the table? But I think they do. So
I agree.
All right. So a couple of other questions I have here. We recently had a client whose landlord sold the building and they were forced to relocate. And I kind of wanted you to speak to that. I don't think most people realize that if a building is sold and they still have time left on their lease, that they can be forced out. So can you speak a little bit to how that process would work?
Sure. Well, one is that there's a lot of, and one situation I know of is where the tenant did not realize that they had not fully complied with the lease. So therefore, the landlord had more leverage in terms of requiring them to move out or being able to negotiate a lesser deal. Also, too, sometimes your lease will allow a landlord to relocate you to another facility that they own if they want to close the building. So if that's the situation, sometimes you're forced to. Now, usually the landlord is going to pay for that, but sometimes the landlord can make you move.
And obviously with a professional practice, that could be quite devastating because your facility might, be something that you've really built out. It might be harder to find an equivalent facility where patients are as willing to come see you,
Usually the landlord has the right to move you. They also have the obligation to make sure that they give you, and obviously there's no perfect comparable, but they have the requirement to build out the new space. So the space is equivalent to what you had before. The rent has to be equivalent, and the space has to be, of a similar nature so that you're not going to lose patients. I mean, obviously, if you have a practice in downtown Chicago, they can't move you to Evanston and expect you to have the same space. But if you're in a suburb, moving across a suburb or to a neighboring suburb, they usually can do.
Right. And I guess that, they have to look at things like patient parking, patient access, security features. It's very tough. It's not a situation that comes up very often, but when it does, you want to pay attention. Now, all these things we're talking about are things that people sometimes will just sign a lease. They don't necessarily have somebody look it over, or they may not really understand what they're signing, but it can make a really big difference when these events occur. Yes. Another situation you and I have dealt with before are things related to signage and hours of operation for a practice. And that sometimes can be a big issue as well.
Well, in a particular in a space where it's a multi-use facility. You have retail and you have physicians. The landlord is going to want to have foot traffic. So often the rules to the lease will say you need to be open 8 hours a day, 6 days a week, which doesn't work for most physicians. So you have to be careful when you're negotiating a lease that you negotiate that time frame out. So you got to be really careful, and often the hours come up in the attached rules. So you have to make sure you carefully read the rules, because most landlords don't have a problem if they're taking a physician saying, okay, 5 days a week is fine. I recognize you're not going to be open Saturday or Sunday. That's okay. Maybe it's 6 hours instead of 8 hours. Usually you're able to negotiate that. You just have to make sure you know up front that it's there.
Right. What about the opposite, where you might be the only practice in a building that's mostly offices? Do you ever come across where they want access to be able to provide services, let's say on a Saturday, but the building is locked or the elevator is not working or there's no cleaning services? I've seen that issue arise, but I'm not sure how common it is.
It is common. You do have to negotiate off the difference. One issue that also comes up is the off hours. a physician who wants to see patients before normal hours or after normal hours. And both of those become problematic if you don't deal with them up front. Heating and air conditioning. You see a lot of offices that say we provide heating and air conditioning from 8 till 6, Monday through Friday. So you want to make sure that if you can be open on Saturday, you have the air conditioning on, or the ability to control the air conditioning so that it is on, or the heat is on. Elevators. Again, up front, you have to let the building know. My hours are Monday through Friday, 7 till 4. Am I going to have heating and air conditioning during those hours? Am I going to have access to the elevator during those hours?
Right.
And is the building going to be open for my patients during those hours?
Right. I think those are great questions for professional practices to really think about, because what you don't want is to get into a dispute with your landlord. I know during COVID, this was a big deal, obviously, off hours. They were staffed, with fewer people, less security, less cleaning. Hopefully we don't see that happen again, but I think it also made people aware of what was in their contract. Another issue related to that is signage. So a lot of times people are just subleasing an office, or they have a new associate working there. They tend to just do the signage on their own, right? They don't necessarily talk to the landlord, and we've had some disputes arise out of that. Do you see that very often, or is that something that we really need to worry about when it comes to a lease?
Well, it is when it comes, okay, there are two issues of signage. One is the outdoor sign, which a landlord is absolutely going to control. The other one is the inside sign. The sign on the door, making sure that the sign on the door reflects who the new tenant, who the new doctor is, and also when you walk into a building and you look at the directory, making sure the directory properly reflects changes in personnel.
Right, and I guess sometimes only certain larger size tenants get their names included in certain places. So if, making sure you understand where the name of your practice is going to be displayed can be an issue as well. You may have assumed that it was going to be in a certain, more clearly labeled spot than it was because you didn't turn out to be a big enough tenant for that.
It's absolutely
right.
So,
all right.
And then the changing of doctors within the practice becomes a big deal too, because the directory, the building directory has to reflect everyone. So you make sure the landlord knows, okay, we brought in Dr. Drake, we need to add Dr. Drake to the directory.
Right, keeping them updated. Great. So one last question I have, and this is something we come across quite often when it comes to doing transactions, which is the assignability of a contract to a buyer. And I know that a lot of contracts will say you can't assign, or sometimes they're not very clear on assignment. And certainly one of the biggest delays you and I experience in our transactions is getting the landlord to respond and give an okay to that assignment. So any advice on that topic?
Well, one, when you negotiate a new lease, there are certain types of assignments that are fairly common in the medical practice. So to try to negotiate up front that a change of business structure, that's not going to require consent. A sale of the entire practice, can we get up front the ability that as long as certain conditions are met, the assignment can occur without consent? Those are big ones. The other one is, and the unfortunate one is, when the doctor is no longer able to practice. He's disabled, he or she dies, able to either assign or terminate without huge penalties, and try to negotiate up front that if the doctor is unable to practice for 90 days, can we terminate and pay, pay a reduced buyout instead of paying off the entire lease? And these are things we're often able to negotiate up front.
Right, that makes sense. And of course, if there's only one doctor in that particular practice, it's a very big issue. And a lot of times the original doctor is the personal signatory on the lease. And when you bring on the associates and maybe partners, they don't necessarily, at least in my experience, always follow through the paperwork and get those people added as personal guarantees. If you're the more senior doctor, obviously try and remember to get the people coming up to become signatories. But from a landlord perspective, if all they have is that senior guy and that's the one who's ill, disabled, or leaving, then the landlord's kind of in a stuck position. So, that's a very tricky topic as well.
Personal guarantee is an important issue to take into account on renewal, because oftentimes the personal guarantee is required to get a landlord comfortable. So when you renew, you're often able to negotiate removing the personal guarantee that's already there. So that becomes important, just on an ongoing basis if there is a personal guarantee.
Right. And sometimes the landlord won't necessarily, you sell your practice, you move on,
Yep.
The landlord's willing to assign it to the new buyer, but they're not willing to quite let you go, even though you're retiring, you're moving out of town. For some period of time, they often want to keep the old tenant as a personal guarantor as well. Do you see that very often?
I do. And sometimes if the buyer is clearly financially capable and financially has the financial wherewithal, the landlord is more willing to release the
Right.
the original tenant. Sometimes they want to wait a year or 2 years to make sure that they're comfortable with the new person.
Right. And I guess one final thought before we wrap up here is the role of the bank in some of these transactions. I know that when a bank is loaning money to a buyer of a practice, they're looking for a commitment. Sometimes it's a 10-year lease or 2 5-year leases, although I've heard that maybe that's starting to change. And they really want to know that wherever they're giving money, that practice is not going to be destroyed by, the landlord terminating a lease or not renewing a lease or something like that. How flexible do you find the lenders to be in those situations? Are they pretty strict about time frame, or what role do they play in that lease negotiation?
Well, I find that the lenders tend to be more flexible, and there's got to be flexibility on both part of the lender and the landlord in that case. Now, again, the landlord's main concern is making sure that they have a strong tenant for a given period of time. So usually they're not uncomfortable if they know that there is a strong financial commitment behind it. The bank has the same concern, and so that the bank wants to know if there is a commitment for a space. So usually we're able to work out something that makes sense for everybody, but it's something we have to deal with up front.
Right. Yeah. And I know the banks are pretty strict. Like, we often have to negotiate with the landlord and say, we really literally can't do this deal, or with the buyer and seller, this deal cannot be done unless we're able to get
a 5-year or 10-year lease.
This length of time. Right. And yes. I don't know. I heard a rumor that the lenders are going to start looking for longer terms even. I don't know if that's true or not, but obviously that, is something that we may start to see going forward. So,
well, the other concern on that, though, is the landlords being concerned about having too length of a lease now where the inflation is higher than it had been. So that's something we haven't quite seen yet, but I'm expecting to see there being less, more concern on the annual increases taking into account changes in inflation, which haven't been that high over the past couple of years.
Well, I guess, we're not talking about an office space where people are going to shrink their space and go in less. The one good thing, I guess, about physician practices, dental practices, people still go in and they still go in person. So hopefully from a landlord perspective, they want to do what they need to do to kind of preserve that great tenant, that they have. So, all right. So any final thoughts, hot topics about questions that, you're getting asked by clients on a daily basis about leases that we haven't covered yet?
I think you've done a pretty good job of covering most of them, so.
All right, perfect. Well, if you guys have any questions that come up to your mind about leases and you want to share them with us, please feel free to do so. You can reach out to Jim Drake or myself. And this has been the HealthLaw HotSpot. You can see some of our other podcasts at ralaw.com. Thanks for joining us. We'll see you next time.
The Roetzel HealthLaw HotSpot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel HealthLaw HotSpot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel HealthLaw HotSpot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.